Good evening. I'm Aditi Aggarwal, founder of GTM Unbound. It's a pleasure to have you all here. The idea of this event came from when two of my friends, Efficient Capital Labs and Paddle, decided to co-sponsor this event for founders to understand technicalities and legal landscape which helps India-US cross-border founders. So I would love to welcome Nikhil, and Nikhil heads partnerships for Efficient Capital Labs. Over to you, Nikhil. Share with us a little bit about Efficient Capital Labs and your journey.
Great, thanks so much for that, Aditi, and it's wonderful to see everyone here in the Bay Area this evening. We have a wonderful set of folks who've traveled far and wide to be with us today. But before we dive into that, a bit more about why did we decide to host an event like this and why Startup Law for Founders is what. So Efficient Capital Labs provides non-dilutive growth capital. So this is financing to SaaS startups, and our sweet spot is the India-US corridor. We have identified this over the 2 years that we've been operating as a major pain point for founders who originate from India, who start building out of India, have teams in India. And clearly, because they're building B2B SaaS, identify the US as the biggest market for them. And then starts the whole transition for them to say okay, so now we need to incorporate in the US. And now we need to start hiring in the US. And now we need to figure out how our various entities across India, US, and possibly other parts of the world, and our various teams, how do they work together? What are the tax implications? What are the legal implications, right? How do we structure our, shareholding and so on, right? And then further down the line, and we're also going to be speaking about immigration today, there are 3 levels of this, right? It's everything from the founders themselves. More often than not, you see founders actually moving to the US to be closer to their customers and their business. Then they would also, of course, if they have families, would like to bring their families with them. And subsequently, when they start hiring, there's 2 parts to it, right? They have teams back in their home countries that they would like to bring on different types of visas to work in the US. And when they start hiring in the US, they realize very soon that most of the technology talent in the US is already on some kind of visa, right? Whether they're coming out of university or working in the workforce already. So all the considerations around the nature of the visas, whether it's for yourself, your family, employees, and the implications on your business, right? And now you're truly a global cross-border business with teams in multiple geographies, with multiple entities, with revenues in multiple geographies and multiple currencies. And when you put it all together, we provide the financing. Yes, that's where we come in. We are by no means the experts when it comes to law, tax, or immigration, right? And therefore, we have brought together a very august panel of partners here from different parts of India and the US today to speak to us and take us through the various steps that I've just mentioned, right? So with that, I'm just going to do a very quick introduction. Actually, I'd like them to introduce themselves. So we can start with NovoJuris. We have Richard and Sharda here. We'll start with you, Richard.
Thank you. Hi, I'm Rich Devlin, partner in NovoJuris. I'm based in the Philadelphia area. I've practiced corporate and transactional law for about 25 years. So my primary areas of help are in startups, formations, corporate governance, M&A, and financing.
Hi, this is Sharda, founder of NovoJuris. We do multiple things at NovoJuris, but what I specialize is fund formation in India, Gift City, which is an offshore, Cayman, BVI, and Mauritius. And we also do the investments from these funds. We've done more than 850 such financings, which ranks us amongst India's top 15 when it comes to number of transactions. Because these are tech companies, they grow inorganically. They acquire companies or they themselves get acquired. So we do a fair amount of M&A as well. India to India, US to US, India, US. And it used to be Singapore as the joke goes that Singapore happens to be India's startup capital, but no more. Many of them are internalizing into India. And we also do intellectual property. The 9 yards of being the in-house counsels for the companies.
Great, thanks for that. And Raghavan.
Hi, my name is Raghavan. I think, as opposed to these guys who have a very wide range of knowledge, I have one area of knowledge, which is immigration. Working in immigration for the last 10 years, Aggarwal, which is where I work, we're based out of Buffalo, New York, have been doing this for maybe 30 years plus. I think my specific experience in the last 5 to 10 years has been very frequently working with companies that I think probably have similar profiles to you guys here, companies of the profile that Nikhil was explaining. But also we do other immigration work, family-based immigration. We work a lot with companies in the US who are hiring people, students who are graduating from US universities. I just came earlier today, I was at Stardex. I don't know whether you guys know, it's like the accelerator from Stanford. We do a lot of work with Stardex, so I just was doing some office hours over there beforehand. So we do that kind of employment-based, family-based immigration work.
Wonderful, and thank you for spending the time and flying into San Francisco for all of us. I assure that half of the audience is your client for sure. So over to you, Nikhil, to
Yes.
cover the first segment with Sharda.
Sure, so
and
just to
Rich.
set some context to start with, we're going to be talking very much on the cross-border startup law, the implications for global startups typically originating from India, moving to the US. And we will involve both Richard and Sharda for that. And then the second half of today's panel, we will be speaking more on the immigration angle, and then Aditi will be engaging Raghavan on that discussion. So I have a few questions here, that have come in from the audience in advance, that have come in from our experience of working with over 100 cross-border startups, right? And I'm sure this is also a very rich experience that's coming through from NovoJuris and all the work you've been doing with cross-border startups as well. So let me start with you, Richard. Rich, when should a founder choose setting up in the US? So one is the timing of it, and what factors should they typically consider? So it's kind of two parts to this.
Right, well, I think both of those factors are driven by business reasons, right? Timing is when you're ready to expand or ready to get into the US market. It's really driven by the needs of the business. The factors for coming here are similar, driven by the business. So you see market potential in the United States, maybe you have customers here, maybe you want to tap into the size of the US economy. So that's business driven. Could be the talent that you're seeking. I mean, a lot of talent is global these days or remote, but if there's talent in a certain area, maybe you want to come to a city with a lot of universities like Boston for tech talent, or the Bay Area, right? A lot of new talent around here. And if you're seeking VC financing, primarily from the US, there's a lot of it here, especially in this area. But those are the main drivers as I see them. They're really business based. You want to be here. You need the talent, the money, and the market.
Sure. And Sharda, would you like to add to some of that, because you are the firm's partner on the India side, right? Before they even make this transition, they clearly have got some, they've got product market fit. They probably are revenue generating already, and kind of fairly successful in the home market. So again, what are the trigger points that you see from the earlier discussions before they start to have these considerations?
Primarily what Richard was mentioning. If it is the market, then typically we have that as an expansion where they incorporate their subsidiaries in the US. But if it is fundraise, largely SaaS companies, they find a better market here, and they find better investments here, and also a market for them to be acquired as entity, which are some of the triggers where they think their holding company should be here. So if it's just business, then it would be a subsidiary that they expand as. But if it is investment or an M&A, then the holding company has to be here. Those are primarily the factors that I see when they expand or set themselves up in the US.
Sure. And then coming back to you, Rich, so yes, so like clearly the decision has been made. They do intend to set up in the US and expand and so on. And then, further considerations, right? So one is, where in the US should they set up? There are 50 states in the US. There are state laws besides federal laws as well, which impact all the organizations that register and choose to operate there. So yeah, there's two parts to that actually. One is you register in a certain state, and there are implications to that. And then you could actually be operating in a completely different state, right? And you may or may not have presence in the state where you registered. So a lot of implications to kind of think through, and choices to make sure you get it right. So would love to hear it from you.
Sure. You're exactly right. There are 50 states to choose from to register or incorporate your subsidiary or your holding company or any business, right? And then what's true in every state is that you don't have to be operating there. You can organize in one state and operate somewhere else or multiple other states. You can only incorporate in one, but you can operate wherever you want. So you probably know this, but by far the most popular state for incorporating is Delaware. Of the Fortune 500, I think 60% or 67% are incorporated in Delaware. That is primarily driven by regulations. Delaware is known as a very corporation-friendly environment. The Delaware corporate law is geared towards really protecting the corporation and its officers and directors. Delaware actually has its own court system just for corporate cases, and it's friendly to corporations, so that's very helpful. However, there are others that are, I guess, trying to compete with Delaware, right? Some are also very friendly. Some you may not even expect. Some of the most popular ones beyond Delaware for tech companies are actually Nevada and Wyoming, right? So, and for various reasons. They're friendly to corporations, they have low taxes, it's easy to incorporate there. Those three states are probably the leaders for ease and protection of your company and the insiders, right? Now going back to the reasons why you would come here, right? Talent, VC funding, and the market. Well, we'll leave the market out of this, but talent and VC funding. I would expect you would want to go where the talent that you want to hire is, right? So tech companies, the Bay Area, California, New York, the big cities have a lot of talent, where the universities are. So you can incorporate in, say, Delaware, Wyoming, Nevada, but create your office somewhere else or be remote. And the reasons you would do that include getting the protections of where you're incorporated, but not having to physically be there. So Wyoming is very popular. It's one of only 2 states with no corporate income tax whatsoever. It's cheap and easy to incorporate, but there's no talent in Wyoming, right? It's mountains and elk and not a lot of people, right? But that's fine, because in the US you can just do it that way. You create yourself somewhere and then operate somewhere else. There's a little bit of a legality in doing that. It's fairly simple though. You have to be qualified to do business in any state where you actually are physically present, but that's simple. It's a filing and an annual fee, which is inexpensive. So, there are other states that are sort of up-and-comers that are also trying to compete. I think Colorado is one for tech companies. Ohio, which was a surprise to me, but apparently there are a lot of there's a good environment for tech companies and funding in, I guess, Cleveland, Columbus, and, Cleveland and Columbus, right? So, yeah, I guess those are really the drivers, the taxation, where the talent is, and VC funding, right? So, California, New York, big cities is where most of the VC dollars go. And Delaware, because most companies are incorporated in Delaware, but where the VC dollars go is really just a function of where these people are incorporated. Doesn't really have to do with the physical location of the state, right? So it's really up to the company to decide where they want to operate if they're operating, but where they incorporate is more of a tax regulatory question. And states that you would think would be popular for incorporating, like New York, California, aren't really, because their regulatory regimes are very complex. the cost of living is extremely high in those areas. So, you know, that impacts talent and what you're gonna do with your employees. So those are the primary factors to consider when you're choosing a location. I would start with the business needs first, but for where you incorporate, go with what's low tax and low regulation.
Sure. Right, and then a follow-up question to that, and then clearly, what is the nature of the corporation that you would set up, right? So clearly that there are a few options here of C Corps, which is almost like defaulting to Delaware, but then there's also LLCs, and there are a few other options. To be honest, in the SaaS space, we hear mostly about C Corps and LLCs, but again, would like to hear from you on other options, and if it is going to be either of these, is there a trend or a preference?
Yeah, the trend and the preference is a C Corp, especially in tech. And in any company that is going to seek VC funding, it's primarily C Corps are requested or required by the VCs. And if your end goal might be to go public, list on a stock exchange, C Corp is pretty much the only way to go. Not necessarily, but it's the usual way to go, right? So other options include a limited liability company, an LLC, which works for some people. It's generally better for smaller companies. An LLC is a pass-through. If you don't know what that means, taxes pass through, so there's no corporate tax. Only the owners are taxed, right? So that's beneficial usually for smaller companies, not that many owners or shareholders. In an LLC, they're called members. And in theory, you could be a partnership, I guess, or a limited partnership, but in the tech space and in companies seeking funding, it's virtually always a C Corp, unless you have a really good reason why you need to be some other kind of entity. You certainly can. You can run any kind of business out of any type of entity, but for people that are looking to the future, fundraising, listing, exits, C Corps are a little higher taxes, which is where your choice of state is important.
Right.
But you have the double taxation feature. Does everybody know about double taxation of C Corps? You know what I mean when I say that?
No, I think you should explain it.
Okay, so we call it double taxation because when the corporation earns income, corporation itself pays corporate income tax on that income. Then when, say, dividends or distributions are paid or salaries are paid, that's taxed by the recipient. So the money flowing through from customers to, say, your employees is taxed twice, right? Once at the corporate level, once at the individual recipient level. With a pass-through entity like an LLC or a partnership, there is no corporate level tax. Everything flows through to the recipient of the funds, so it's taxed once. So that's a benefit, but for the other reasons of sort of expansion and funding, most companies choose a C Corp.
Right. Yeah, and I think that's important because incorporation is a one-time activity. You don't want to be choosing an LLC with a very short-term view in mind, and then starting to realize that, hey, I'm moving towards an IPO and so on, and this was the wrong choice.
You can convert. I mean, you have to go through that process. It's not, for a small company, it's not that difficult, but it is a process and there's costs involved. So if you know you're going to end up as a C Corp, you might as well start there.
And if you are granting ESOPs to early employees, then C Corp it is.
Gotcha. Yeah. So we'll talk about a bit about that as well. That's of course a very important part of any founder, any early stage startup. ESOPs is critical. Not just to the way you're structuring a company, but how you attract talent as well. But Sharda, as a follow-up to what we've been speaking about, so if this business does have presence in India, and the founders are paying tax actively in India, then how should the India and US entities be structured, right? So there's precedence here, there's already an India entity and there's the founders paying tax there, and then incorporating the US. What are the implications, for the way the India and US entities are structured?
Sure. So going back to the first conversation that we had on the reason why they want to expand into the US. Now, if it is a market that they are after, then they have a choice of having a subsidiary company while the holding company could still be in India. So what does the holding company mean? It means captive IP ownership, perhaps ESOP, exits, which is where investors would come in. versus a subsidiary is usually 100% owned by the main holding company, and it gives a contractual ability for the subsidiary to sign up contracts with customers. It's always felt by the Indian founders that having a US company as a contracting party gives, especially SaaS, right, an ability to, an inherent premium in their subscription fee, etc. If it is clearly not just market but also investments, then the holding company matters. So the holding company has to be in the US, which is where the investment amount would come in, and for the rounds, plus the exit happens at the holding company level. Now, there was a time when accelerators like Y Combinator, etc., would want their companies to be incorporated in the US. And Techstars, Y Combinator, most of them would want their holding companies to be in the US. And therefore, many of the founders found it necessary to incorporate, even though the market was purely India. And there used to be a time when we had a regulatory sort of a loophole, if I may call, which said that, okay, if you have to incorporate, then the founders would kind of have somebody who would incorporate and give the shares to the founder. And the Indian regulator now woke up and they said, oh, by the way, if you, and there was no mechanism for the gift of shares to be reported to the Indian regulator. So that was the loophole, which recently got plugged, saying that, hey, if there is a gift of shares, then you still need to report it to the Indian regulator. Plus, they brought in this 10% control mechanism, which said that if the Indian founder or any Indian resident individual owns more than 10% in the US entity via an investment from India, they cannot have a subsidiary. So that became an issue, which means that now most of the founders kind of pool themselves into an entity, and that entity kind of invests into the US entity, incorporates that, and then that entity has an operational entity back in India for its R&D, etc., as a cost center.
Yeah.
And the other part is, when people are still figuring out, I don't know whether I'll raise money in India or in the US, they kind of set up it as a standalone, and they'll figure, okay, wherever the investment comes, then that becomes the holding company. So these are the typical issues that I see from a regulatory perspective in India.
Good. And Sharda, you brought up an important thing. You just mentioned R&D being, done, let's say, out of the Indian entity and so on. So one important part, and this is actually a moat, it is a differentiator for any company, and not in the least for a SaaS company, is to be able to, not just develop IP, but also patent it and, differentiate based on that, right, with your competition and so on. So what are the implications on IP when you have, a multi-jurisdiction kind of setup across countries, with holdco, step-down subsidiary and so on? And also from the perspective of structuring your cap table, being able to, grant shares to not just, your employees, but possibly also consultants and so on, right? There's a lot of considerations around that. So if you could touch on both points, IP and the cap table and share.
Sure. So if it is a subsidiary situation in the US, then all IP would be at the holdco, which was back in India. And then this is more like a India entity would license its IP to the US entity, therefore they could get into a contractual relationship with the end customer. But if it is a holding company in the US, then India would become a cost center, which means India entity would do a cost plus model as a work for hire situation, a master services agreement between the US holdco and the India sub. The India entity would create the IP, and because it's a master services agreement, all IP gets owned by the US entity. Therefore, the valuation of the holdco is intact when it has to attract investments. And India is people, and it's just one customer, which is called the US holdco. That's typically how, when it is a US holdco. In terms of, your other question is?
On the cap table and
On
share
the cap
holding
table. So
ESOPs.
it's a function of where the holdco is. And if the holdco is in India, then it's all the India regulations. But if it is in the US, then because of the investment coming into the US entity, then how do you capitalize in the India entity, or how do you move the money into India, because that's where the expenses are three kinds, right? Either you capitalize the India entity, which is an equity investment, or you move the money as a loan to the India entity, which is not the preferred route, or it will be an invoice mechanism, a master services agreement between these two entities. Of course, transfer pricing regulations come into play. So the master services agreement says that the India entity will be, developing the product as a services arrangement. All the IP sits there, and it gets paid for the work done. And this can be replicated even for a standalone, more like a contractual agreement between the two entities. These are typically how they engage.
Got it. And also, like we hear this from time to time, but just the awareness that, whether it's a possibility or not around ESOPs and granting. So, of course, granting ESOPs to your employees is a given, irrespective whether it's, you're an India entity or a holdco or a US holdco. But what we see a lot in the US, especially at early stage, and again, this is a way to, grow, attract talent or attract consultants, right? And in the US, you can grant stock to consultants, ESOPs, right? And that's a very critical way to grow at an early stage, when you may not be able to hire a CXO and so on. That's not a possibility in India, right? So there are some considerations around this as well, and when you're trying to look at what your options are, right?
You're right. So in India, we do not have a huge variety. We just have a board-administered ESOP scheme or a trust administered ESOP scheme. And these are meant for, it's an employee stock option pool. So typically what happens in ESOP, if it is board administered, then the usual, right, a vesting period. It's a grant, not a tax incidence, a vesting, not a tax incidence, but at exercise it becomes a tax incidence event. Now for advisors, etc., it's more like a sweat equity that you get, and many of them via the ESOP trust. Also, they call it as a management stock option pool, and they issue stock from that particular trust to advisors, etc. Or if it is directly to an advisor, it's not called an ESOP, but it is called as a sweat equity directly from the company, but it's a tax incidence again. But in US, you have multiple other ways of granting stock options.
Sure, you can incentivize your employees in a number of different ways. It can be an outright grant of shares. It can be stock options to purchase shares later. You can create some kind of RSU or restricted stock unit, which is basically something that will track the performance of the company or the shares, but actually pay out in cash. So you don't really have a share, but you're participating in the same growth, same way. ESOPs in the US are, there's tax regulation that you have to comply with for the really to be beneficial and tax advantageous. Similar to India, they can be managed internally, or you can have an outside trustee or consultant that acts as a fiduciary for the participants. Private companies generally can fund their ESOP directly by depositing shares, or if you happen to be a public company already, you can fund your ESOP with either borrowing, there are actually ESOP lenders, or put cash in there, which would buy shares on the open market for for the employees to receive. I mean, we're really talking about private, smaller
Yeah,
companies
it's
here, right?
small companies,
So, multiple ways you can do it, but you can structure it. If you follow the sort of the IRS guidance on making sure that what employees get is taxable later, your payments are deductible, then you can, the actual thing you're giving them can be sort of almost anything tied to the equity, right? So,
Right. So, but just
There's another interesting point for advisors, etc., where you don't have to dilute your cap table with ESOP, called phantom stock options, where think of it more like a HR incentive, but the price is linked to the stock price. So an employee joins when it is 100 rupees, and when the employee leaves, it's 500 rupees, so 400 rupees is into their account, but it's a cash settlement, not an equity grant.
That's interesting. And just to be clear, that the tax implications are the same on, grants, vest, and exercise, right? Whether it's India or the US,
It's at exercise.
it's an exercise, right? So that's consistent.
It's different.
If it's a qualified plan, qualified with the IRS to be a compensatory plan, then yes, it's the same. If you don't go through that process and you just give someone an option without a plan, that's taxable at that point. Not before it vests, but if it's an option, the option itself does have a value, right? So in a non-qualified plan, it's taxable when you grant the option. Qualified plan is taxable when you exercise. So it depends on how you structure it.
Can we ask questions?
Sure.
Yeah, sure.
So, since you both are here from the US side and the India side, and there are a lot of cross-border founders where all the employees are in India, your entity and all the value is accruing in the US, you're raising money here. So how do you grant the stock for India employees? We would want to do where our IP is and value is, right? So in the US entity to India employees, and what is
Let me take both. So if the ESOP is where the holding company is.
Yeah.
So if it is a US holding company, the same scheme, the same pricing, the same should be applicable even to the India employees. That's what our RBI regulations say. So when there is a grant, you don't have to report out, but when there is an exercise, then the company, the Indian entity will have to report out to RBI. Now, it's fairly simple. The taxation, because the employee is based in India, and that employee pays tax on his global income in India because of his tax residency, then in India it's considered as a perquisite tax, and he pays tax in India. A report happens to RBI. If it is, say, India holding company for an employee in the US, then you can still issue the grant letters from the Indian ESOP scheme to the employee in the US.
So technically, it doesn't matter if we hire an employee in the US and in India, they're on the same cap tables, everything same.
Yes.
ESOP structure.
Yes. We have Capital here.
Yes.
You can talk to them more on how this works seamlessly.
Great. Yeah. So we will have a breakout, of course, soon with the audience on open Q&A. But coming back to the panel, and Rich, a question for you on 83B tax filings. Should the foreign founders, and presuming they're from India, LATAM, other parts of the world, non-US, is this a cause of concern for a foreign founder, 83B tax filings? And the second part of that is, when should they elect, and what happens if they don't elect, right? So there are implications on both.
Okay, so 83B is a reference to the Internal Revenue Code, that section. So if you are not a US taxpayer, you don't have to worry about it, right? So if you're a founder in India, your income is from India, you're not a US taxpayer, then it's not something you have to think about, right? But I'll tell you what it is. So if you're in the United States or a US taxpayer, Section 83B is an election you can make if you are receiving equity that has not vested yet, right? Typically, if you receive say you get a grant of shares or an option, not in a qualified plan, but you get something of value, it's taxed, right? So, and it's taxed when you receive it. Section 83B allows you to make a choice. You can say, well, let me back up. You're taxed when it vests. So you may get a grant of shares, it's gonna vest in 2 years. You're not taxed until it vests, right? But when it does vest, you're taxed at whatever the value is then. So when you first get the grant, you can choose to pay your taxes now at today's value, which in theory is lower than it will be in 2 years, right? So you make the election, you have to do it within 30 days of getting that grant, or else you don't get a choice anymore, right? So you make the election, file it with the IRS, it's just a notification, I wanna be taxed on my grant now at today's price. And then all the gain thereafter is capital gains. So the rates are lower than ordinary income, right? So you would do that if you expect the value to increase, especially substantially. Now, you really have to do the math to see if it's gonna work for you, right? Depends on how many shares are we talking about, how valuable are they, is it worth doing it, right? So if you don't make the election, then you're gonna be taxed at ordinary income rates when your shares vest, which could be a year from now, 2 years from now, whatever. So in a high growth company, usually makes sense to do it. You can get into trouble if you're a really new startup and you think it's going to appreciate, but it doesn't, then you've paid tax basically on something that, on income you're never really gonna get, right? So you have to make that calculation, be pretty confident about what you think is going to happen. But yeah, the IRS will give you a choice, pay taxes now and establish your basis, and then have all capital gains, or wait and see what happens, but you might end up paying more in taxes.
Correct. And just to be clear, this would be applicable not just to the founders who are paying taxes, but also possibly employees
Anyone.
who are foreigners but paying taxes in the US.
Anyone receiving a grant that doesn't
Anyone.
extend it.
So now coming back to Sharda, a bit more about what are the different kind of working relations that you would see now that we're talking about having established an entity in both India and the US, whether it's step up, step down, subsidy and so on, but also, implications on the way you're running these as businesses which are linked to each other, tax implications as well. And the fact that, yes, in all probability, you could also have entities in other jurisdictions and other geographies. It's not always just these two, maybe it starts with these two, so we'd love to hear.
Sure. It depends on what exactly the two entities are working on. Now, if it is all operations, say like a fintech company, but has a holding company in the US just because they wanted to raise money, then they would perhaps capitalize entirely via equity investment into the India sub. If it is product company, say, I'll just take the example of SaaS, then perhaps India will be more like a cost center. Therefore, a master services agreement is what will happen. The IP will still be with the US, therefore it's a services agreement. If it is, say, a standalone entities, then it could be license of IP for further selling, like a reseller arrangement. Going back to the tax question that you asked, that because it is a resell of the product or the service, then you would choose whether I will do it as a royalty mechanism or a commission mechanism. Royalties are less taxed versus a commission. Commission is GST 18% back in India, versus royalty is about 6% taxation, 6 to 8% taxation. You also get to choose which jurisdiction you want to pay tax, because India it's 25%, and depending upon where they are operating in the US and what the taxation is, you'll determine where to have that commission or the royalty fee stay. If it is India, 25% taxation, right, subject to tax deduction on sources, etc. So that's largely how one can think about.
Great, thanks so much for that, Sharda and Rich. It's been a great, insightful conversation. Not just for me, I hear this so much from my customers, but actually to understand the legal implications of having a genuine cross-border startup set up both India and the US. We are now going to move into the second half of our panel for the day. We're going to have Aditi from GTM Unbound and representing Paddle as well. Engage Raghavan on immigration law.
So who wants an L1 or an O1 here from the crowd?
Depends.
This is visa pace of time, gentlemen.
That is the $1 million question.
All right, so let me begin with the first question, which is the hot question for the hot topic for all the Indian founders building global companies they set up, and they're always anxious with this environment. So how should we start looking at an O1 or an L1? What is the difference? First principles, basic fundamentals for us to start preparing.
Sure. I think maybe the question should go back a little bit earlier, right? To say, when do I need either of these? I'm not sure whether this is working, but you can probably hear me because there's not many. You may be able to say, I can enter the US and work. Well, work is a difficult word. I can enter the US and engage in the activities I want to engage in without first getting an L or an O. In fact, I suspect that is true for everybody here, right? Who is not from the US. So at first, the question is, what things can I do when I'm still a visitor, right? And those things are what the government would say is normal business visitor activity. I'm attending meetings, I'm attending conferences, I'm getting training, not giving training. I'm meeting with a client that we currently retain, maybe it's an existing client, to gather requirements, gather information related to a project that we're working on, but then the actual delivery of that project is going to happen outside the US. Or I'm meeting with an investor to try and gain investment, or I'm interviewing. These kinds of activities are considered valid, reasonable business visitor activities. So if all you are doing in the US is that kind of activity, then all you need is a B visa. Or if you're from, I guess most of the people here we're talking about from India, if you're from a country that the US has a kind of agreement with the visa waiver program, maybe you can just enter on what's called ESTA, and you don't need the B visa stamp, but you're still entering as a business visitor. But even if you can, even if that is the only thing you are doing, if you're going to spend a significant amount of time in the US, you're going to get increasing scrutiny. Every time you enter, the officer's going to look and see, how often have you been entering? And if it's, I've been entering every 3 months for 6 weeks at a time, and now it's been 2 years, and so really you look back and I've been spending 6 months out of these last few years in the US, you got a higher chance each time you enter of an officer saying, are you really working? What are you doing? Are you making money in the US? Are you doing what would be considered a job and therefore taking that job from some American who could be doing it without acquiring work authorization? These are the things these officers might care about, right? At which point you have then the question, okay, what do I do for work authorization? And probably for you guys, it is either the O1 or the L1 that are kind of primary strategies that you look at. So what are the differences? Well, the first thing is they are completely different, right? They are just different, I guess, categories of status in the US. If you think about it, probably you'll recognize, all of these things are related to some letter of the alphabet, because that letter of the alphabet is the subsection of the regulation that has these words in it, right? So that's why they're called the B, the C, the D, the E. It's just because that's subsection B, right? And so the L1 is because it's subsection L1A that says you are a manager or executive of a foreign company and you're coming into the US to work in a position that's managerial or executive for an affiliated company in the US, right? So that's what L1A is for. L1B is for a person who's working at a foreign company in a position that requires specialized knowledge. and you're coming into the US to work in affiliated company in that specialized knowledge position, right? So immediately you can see from an L perspective, it's about the two companies, right? It's about being a multinational organization. Technically, you don't need two companies. I think it sounds like from what these guys are talking about that it might make sense to have two companies in many of these scenarios. But you don't, from an immigration perspective, require two companies. You could just have a US company that has a branch office in India. So there's no separate entity in existence. But there's a branch. What's the definition of a branch? I mean, that's a conversation you're gonna have, well, that's a submission and response you're gonna have with the immigration officer, not really a conversation. But you're gonna present evidence to try and say, look, it's a branch office. And they're gonna say, no, give me more evidence to show it's a branch. So it's much simpler if you had two entities, but you can make the argument if you have a branch office. Then the O, which is subsection O, 1A, is, well, there's O1A and O1B. Probably for you guys, we're thinking more about business, right? You're not working in the arts. So we're focusing more on business, where that means the type of activity you're gonna perform in the US is an activity in which you have extraordinary ability in that field. And the regulation defines what they mean by extraordinary ability. I would say the government would argue they're defining that objectively, but in practice, it feels much more subjective in terms of definition. One way you can be eligible for the O1 is if you've won some major international award, right? And so many people know that, they understand that, they think of that, and they say, okay, and they use that as the framing device to think about qualifying for the O1. But I think that that's incorrect, because if you think about it that way, then you assume only people who win Nobel Prizes get the O1, right? But that's not the case. There's very few people that have won an Oscar, a Tony, a Nobel, a Fields Medal, right? So most of the people getting O1s have far fewer qualifications than a Nobel Prize winner, right? They meet the other criteria for the O1. They've got these 8 different criteria that are listed out in the regulations, and they say, if you can satisfy 3 of these 8, then you can be eligible for the O1. So biggest difference, I guess, is the L1 cares a lot about the company structure. The O1 cares a lot about you as the person and what you have accomplished already in the past. And so they're very different in that sense.
Thank you. And while we're understanding the difference between the two, founders come with their partners and also want to plan ahead of bringing their family. Could you also share, I mean, with the possibility of the partner having the chance to also work when they get to the chance?
I mean, so that last part is the key difference, right? It's the key question. Because every visa type, I guess to be technical, right? A visa is the document that's in your passport that lets you into the country. We just use the word visa to talk about these different categories, but technically it's like a status that you have in the US. And if you're outside the US, then to get it, you both need approval for the status and need a visa to get in. But all of you currently are inside the US, right? So in theory, you could tomorrow file for an O1, change into O1 status, and never need an actual visa, right? Because you're here. And if you then choose to never leave the US, you never have to get a visa. But at some point you might choose to leave, at which point you need the visa to get back, right? But visa processing is just a question of, are you a criminal? Are you somebody who's violated immigration rules in the past? It's kind of an admissibility question, right? So the real question is on this status side. And every one of these statuses allows you to bring your family, right? Anybody who is actually in a legal marriage, right? I know that there are some other countries, India I don't think is one of them, but there are some countries like Canada, for example, where you can just be in a common law marriage, right? You've lived together for a certain period of time and you get certain benefits by doing that. But the US wouldn't recognize that as an actual marriage, right? So you need to be legally married in whatever country. It could be a marriage in India, it could be a marriage in, Jamaica or something, right? But as long as in that jurisdiction it was legal, then they'll say, okay, you're married. So you can bring a spouse and you can bring any child that's under the age of 21, right? So those people, so that's unmarried and under the age of 21, right? So if you have a child who got married very young, then they may not be a dependent, right? And so they're all going to allow you to do it, L1, O1. big difference is an L2 spouse automatically has work authorization in the US. They don't need to apply for any separate work authorization. Just by being in the US in L2 status as a spouse, they can work. But an O3, which is the dependent of an O2, of an O1, an O3 spouse cannot work in the US. And there's no way they could apply to work in the US unless they apply to change their status.
And what sort of work is an L2 dependent of L1 visa allowed? Like, is it a job?
Anything. They could work at the Chipotle down the street that I got food at earlier, right? They could just say, hey, I'm an L2 spouse, here's my proof of work authorization, and do whatever work they want, get paid for it, not get paid for it. They can do anything, work for a US company, a foreign company. It's a much, much more broad authorization to work than the L1 or the O1, which are tied to working in your field of expertise or working for your company that you worked for abroad. The downside is you lose your job when your spouse loses his, right? So he's the problem if you're on the L2, right, in terms of maintaining your status.
Interesting. And the big question is that, I mean, a large range of folks here are founders who want to have an option to have unlimited access because they're exploring the opportunity of expansion of the business, which is why they travel. And immigration comes much later and not to each one of us as a question. So what are some of the red flags that we should absolutely avoid, which might, and
Sure.
what are some of the things that we could plan officially?
Sure, so, I mean, what Sharda and Richard talked about a little bit was what's the inflection point in your business at which you're now expanding in the US, right? And I'd say, immigration would also care about that inflection point. If you're at a point in your business growth where most of your operations are in India because you've done what one of these guys described to say, hey, product and development and initial client base are all in India, but I have a US entity because US companies want to contract with them, or because I'm getting US investment, right? So you have the US entity, but you're not necessarily really using it or operating with it. But you need to be able to enter the US because you're trying to grow US clients. Probably in that phase of your growth, you just need to enter as a B visitor, right? Because you're not doing productive work in the US. But even though that is the true fact, that doesn't mean that's what the officer is going to believe, right? So when you enter, it's always a good idea, if you're entering as a B visitor, to have a clear set of documentation and information to be able to explain, here's my itinerary. I'm coming into the US for these business meetings, this conference, and this event or these interviews. Here's the timeline I'm going to be here. I bought the return flights. I have hotels, have all that documentation with you. Then when you enter the US, you come up to the airport officer, most likely. You're probably not coming to the border, but you might have flown into Toronto and then you're coming across the border. So you're talking to the officer, okay, what's your purpose for entry? Hey, I'm entering as a business visitor. I've got some meetings, a conference. That's what I'm doing. Oh, okay, when is that? It's in October, so how long are you planning on being here? Probably around 3 or 4 months. I've got to meet with some different clients and then go to these investor meetings and then I'll go back. Okay, great. That might be your entire interaction. Or, well, how do I know how long you're going to stay here? Oh, well, I have these emails that confirm the dates of where I'm coming. Or I paid for the tickets for the conference already, so here's my evidence for that, right? So you have the evidence with you, not on your phone, but literally printed out with you. And you're able to, if you're asked for it, say, oh, here's the proof, here's my return flight, here's my hotel stay, right? The biggest reason you don't want it on your phone is because then that requires you to show them your phone. And they do not believe that you have a right to privacy. So they will say, oh, great, I'll take a look at that. Okay, let me scroll through all the things. You have a text here where you seem to be meeting somebody to smoke. I believe you are a marijuana user, and so you are not allowed in the US. This is not a joke, right? This legitimately happens frequently, right? don't give them your phone unless it's seized. So you have this evidence with you so that you can demonstrate what you're doing, but your approach is not proactive, right? It's reactive. It's, I'm entering for this reason. Okay, great, go ahead. I have more questions. Here I have the evidence to answer those questions. And you kind of increase your risk, I guess, every time you're entering if you're spending lots of time in the US, because anytime an officer could ask you, well, what were you doing last time, right? And you want to be able to answer, I was here for these meetings or this interview and I left, right? You should be careful, because even if last time you entered for 2 weeks and you left, if this time you say, last time I was here to work, you know, they could say, ooh, that sounds like you misrepresented your purpose for entry last time, you know? So you should just generally be on alert and careful about what you're communicating with them, which is why at some point when it becomes really critical for you to be entering the US frequently, or to be doing these kind of things where really I want to be at the client's site, I want to be doing meetings, doing all of these things to be here to grow the company, you're reaching that inflection point of, I need to get the O or the L, right? Probably it's the point at which my business is ready to really expand if I can be here to do it, which is what I hear from people all the time, right? I just need to be there and then I'll be able to grow it. Probably it's best to do that when you can get a status, but it's not required, right? You could say that's still valid business visitor activity. I haven't spent a lot of time previously in the US. I'm low risk to come in and just, you know, come for these meetings for the next 3 months. Does that make sense?
And a follow-up to that, you mentioned that you can come here for meetings, you can come here for events, but what does that mean when you say that you should not be making money here? I mean, if we have a Delaware, let's say Delaware Incorporation, and we are doing meetings and so on, we signed a contract, we will be eventually making money, and it will be happening all legally. So what is?
Yeah, I guess the distinction there is that you're not making money. Your company is signing a contract, right? And that money is going from the US client to your company to pay your employees in India. And you are here to negotiate this contract and then perhaps to do initial requirements gathering for the project. But you don't have well, in my example here, and you may listen to what I'm about to say and say, but yes, I do. You don't have a US entity that is paying you, kind of salary to do this, right? If you had that, then you've almost definitely got a problem, because the officer is going to say, well, wait a second, you're CEO of a US-based company with money going from that company to your US account. I'm pretty sure you're working, right? So it's very important if you're in this phase that you're saying, nope, I work for the India entity. I'm not getting paid to be here in the US. I might be generating money for my company because I'm signing a contract, but that contract is going to be executed on by the people in India. And at some point, if you're doing it a lot, yeah, even though if they really believed you and you were able to clearly show it, you are doing valid visitor activity, the cost of having the argument isn't worth it. I mean, I think this is probably something that every lawyer would say, right? Like, just because you're gonna win an argument doesn't mean it's worth it to have it, right? So the cost of having the argument may be greater, even if you know you're gonna win in the end. So it's better to do the other plan, get the O1 and then don't have the argument, and now you don't pay that cost, right?
Especially with the lawyers.
Sure, yeah, for sure.
And I also want you to throw some light. Of course, I'm sure in the interest of time we can't go in detail, but what is the path to green card for a founder? If we are seeing the opportunity here, we also want to understand the stability. Often we are at that point, in our life, at least in the 8th cycle, wherein we want to explore this opportunity.
Sure. So I guess, so I'm a partner at Serotte Law. The senior partner, Michael Serotte, would be disappointed in me if I didn't say the first path is marry an American. Right, so I mean, that is clearly going to solve your problem.
What if that?
For some of you, that may or may not be an option. But yeah, so if you're not going down the marry an American path, then marry somebody who's not Indian, because then you'll join their queue. But no, so
for Nikhil and I both,
right.
that option is out. So what is the third one?
Sure. So the third option then is, yeah, I mean, there's a couple of, or several different employment-based pathways to green cards, right? I guess the first thing to understand, or at least the first thing I want to express, because I think people don't understand it, is immigration is not a set of consecutive steps on a path that you are fixed on from the beginning, right? If you choose to file for an L1, just because there is a green card pathway that looks analogous to the L1, does not mean you must follow that path, right? It does not mean you're required to, and the L1 wasn't a prerequisite to follow it either, right? You might obtain an O1 and get your green card because you're eligible as a manager or executive of a multinational company that you worked for abroad before you came in on the O1. You didn't need to get the L in order to be eligible for that, right? So these are kind of two sides of a coin rather than a second step you take after the first one, right? And so what are the green card pathways? I mean, there's several of them. Probably most applicable here is going to be something that's analogous to the L, the manager executive pathway, or something that's analogous to the O, the extraordinary ability pathway. But I don't know, sometimes the company you're working for in the US may not be a company that you yourself have significant ownership interest in. I mean, it might not be, right? Maybe the way your growth happens is you work for the Indian company, you come to the US, and with the investment, with co-founders, et cetera, you have 20% ownership, 15% ownership in the US company. It is possible with a certain amount of ownership in a US company to do the, I would say, perhaps standard green card employment-based process of testing the labor market, doing a permanent, what's called a perm application, and then obtaining employment authorization or employment-based job offer for a permanent position. The downside really is the length of the queue you're waiting in, right? So when you are hearing about these green card paths, you're probably hearing people say EB1, EB2, EB3. The EB, just like I was saying, the L, O, and A, those were all things that are letters in the regulation. Well, EB stands for employment-based. 1 stands for first, right? So employment-based first preference, employment-based second preference, employment-based third preference. That's what EB 1, 2, and 3 mean, right? And the employment-based first preference, the reason we talk about preferences is the US government, at least, is, they would say, completely unbiased in where you come from. Everybody, no matter what country you come from, has exactly the same number of green cards available to you. In practice, because way more people from India and China will apply for a green card, it's kind of irrelevant that somebody from Mozambique has the same number of green cards available as somebody from India, because way fewer people from Mozambique are applying, right? So in practice, what ends up happening is there's massive backlogs for people from India, not because you have fewer green cards available, because you have more people applying, right? And so every month, the Department of State puts out a visa bulletin, they call it, and says, hey, if you were born in this country and you have an approval for an employment-based visa process, immigrant visa process for the green card, and you have a first preference or a second preference or a third preference or a fourth or a fifth, right? There's these different criteria, then you can actually get the green card. You can actually apply for it if your priority date, your date in the queue is X or earlier, right? So they put out these tables, you get these priority date tables. And what that practically ends up meaning is that if it's second or third preference, if you're born in India, you've got a queue of 12 years, 13 years, which means you did all the steps to get the green card from the US, from the company side, but you can't actually apply for it because of the massive backlog. So the O1 equivalent green card, the extraordinary ability, is EB1. The manager executive is EB1, which means in theory you're the most preferred, you have the shortest queue. Maybe 4 or 5 years ago, that was no queue, right? Right now, there's about a 3.5 year queue. But when we say that, we don't mean they are telling you, right now you will have to wait 3.5 years. No, they are telling you, right now, if you have a date that's 3.5 years ago, you can file for it. Tomorrow the dates could move forward by 2 years, right? It could actually move very quickly. In practice, tomorrow the dates could retrogress, right? It could be longer than 3.5 years. But that's how that kind of dynamic works. And so, I don't know, that was a really long rambling answer to say that don't think of it where if I get an O1, I have to get an EB1 for extraordinary ability. You could get the O1 and then do the manager executive. But yeah, that was hopefully responsive.
Thank you. Yeah, no, it was, and you answered almost the next 3 questions in this one, so it helps.
Excellent.
Thank you for making my job easier.
Yep.
Last one from me, and then we'll take a couple of questions from the audience. And I might be able to, also put this out of the recording if you want it to. We are super anxious when we hear that because of change of government and possibly Trump coming in, immigration, especially for Indian entrepreneurs, might get harder. The processes might be delayed. There might be, so there's this whole anxiety around it, which really keeps us away from the primary goal, right? Like we are here for just to create impact in the company, and so please share with us, like, is it actually? What is the real side?
Sure. So I guess anybody who tells you they know the future is lying to you, right? So it's hard to predict, definitely. And if there's one thing that we have experienced from a Trump presidency in the past, is it is chaotic and potentially unpredictable, right? But there are things that we can learn from the fact that we've had Trump as president for 4 years before, right? I guess we've never had a Harris administration, but we've had a Trump administration. And in the Trump administration, for as much as you may have read about or heard about barriers that he wanted to put in from an immigration perspective, on the business immigration side, practically, we did not see it becoming harder for people who have extraordinary ability or people who are managers or executives of companies to get L1 or O1 status approval. Visa stamping is a different question, and that's also a hard one because some portion of the Trump presidency also overlapped with the COVID-19, right? And so then that was a huge problem for visa processing because they were just closing travel and those things. But visa processing is kind of a difficult thing to know because the consulate's just going to tell you when they have appointments available, and sometimes it takes a long time and sometimes it doesn't. But the substantive adjudication of cases, I would say it became easier to get an O1 during the Trump administration than it was during the Obama administration. Will that actually continue to play out in the next Trump administration? I don't know. But at the very least, they're much more, without trying to inject my own political beliefs into it, I would say Republicans are much more focused on being corporate and business friendly than they are on being union friendly, for example, right? So they would be much more interested in expanding the ability for a manager or executive for a company where a corporation is saying, we need these people, you need to do this, than a regular skilled worker coming in where a union might say, hey, we need to raise the salaries for H-1B workers because it's hurting US jobs. So what will happen, I don't know. But what did happen the last time Trump was president is it became easier to get O1s. So who knows what will happen the next time, right? Probably I would say also that it takes time for these things to trickle down, right? Practically, let's say Trump wins the election in November, right? Then it's not gonna be until January that he's actually inaugurated. And then after that, he's going to have to appoint heads of certain agencies. And one of those is gonna be the Department of Homeland Security. And once he gets a DHS head, then they're gonna have to say, okay, who do I want to run the California Service Center and the Texas Service Center and those kind of things. So it's gonna take time for those people to change. And in the meanwhile, officers are gonna be adjudicating as best they can on the basis of information that they've already got, right? And then eventually, they might say, hey, we want to update our policy to now require these kinds of evidence for these kind of scenarios. And that's then going to trickle down to officer adjudication. So it may take several months, even if they do want to impose more strict restrictions before those practically happen. But the one big exception to that is the potential of visa processing issues, right? Like maybe it is possible very quickly for them to say, hey, we're going to stop interviews for green cards, or we're going to stop interviews for this. in practice, that didn't happen so much until COVID, right? COVID-19 stopped a lot of those things, but will just general processing stop? I doubt it. And I guess my approach would be to say, don't plan your next steps on the basis of a possibility of something happening in the future, right? Work on the current system until they change it.
Thank you. This is super helpful. Last one, because you mentioned something related to timeline. Is L1 faster than O1?
So there's a couple different factors to think about in terms of timeline. There's how much time will it take me to be ready to file my application, right? The nature of the evidence that you're collecting for an L1 is theoretically more objective. Maybe that's a subjective opinion on that, but for example, the criteria of evidence is the foreign the foreign company operational? Okay, here's the last 2 years tax returns for the foreign company. Here's the financials, audited financials. Is the US company operational? Here's the certificate of incorporation, a bank statement, a business plan, whatever it might be. Are the companies related? Here's stock certificates. All of these things are objective pieces of evidence that exist, right? Then, have you been an executive? Maybe there's a little bit more subjectivity there, but probably you could say, yes, here's my board meeting minutes for the Indian company that shows, look, I've been a director for the last year and a half. Here's emails, here's proof that I signed these contracts, all these kind of things. That tends to be easier to collect. Well, I believe philosophically that's easier to collect. Does that tend to be easier? Not necessarily, because often when we're working on collecting these things, you work through several levels. I would say if you are interested in working on one of these things, make sure you're either the point person sharing the documentation or the person you know who's going to be able to get the docs is the person doing it, right? Because if we ask you for something and then you tell your HR person and then they give us something gets lost in translation, right? And then we're like, hey, you said you managed 5 people, but I have evidence of 4 people, and this person's pay stubs say VP of Finance, but in the job description you said CFO, and in the org chart it says financial officer. Like, these things don't match up, right? That is the biggest time sink for an L, because you're just trying to get all the documents to match up so that when you submit it, an officer's not immediately thinking, this is shady, right? So that takes time, but in theory that works faster. For an O1, there's some objective evidence. I really did get this high salary. Okay, here's my tax document that shows I got paid it and confirmation I was working at this company. But I played a critical role at this company. Well, we really need to get a letter from somebody at that company that confirms what your role is. Hopefully with objective metrics. Hey, they increased the company's profitability by 200% or something like that. But still, it's something where we're reaching out to a third party to get that evidence. And that can be more time consuming because you gotta find the person, they've gotta agree to sign off on the letter, they've gotta give you the signature on the letter. So I think O1s can take longer to get because the nature of the evidence takes longer to get. Once you're ready and you file, they both have the very same timeline. You premium process, the government responds in 15 business days, same with the L as with the O. But in my experience, the L can move a lot faster than the O because the O is contingent on third parties, sometimes. Not always, but sometimes.
Thank you. This was super useful. I think we'll end the session and we'll have.
Absolutely. I think session's been recorded, so we can complete the recording of the session, and then we can
Talk about all the illegal things afterwards.
Absolutely. We can break out. We have a large group audience here in the SF Bay area. But again, just as a quick wrap for today, we have 3 lawyers who have traveled not just from the East Coast of the US to San Francisco, but also from India to be with us here today. So first and foremost, thank you so much again to Richard and Sharda from NovoJuris and Raghavan from Serotte Law, and also to all the wonderful folks who've come and joined us here on a Friday evening in the SF Bay area. We know it's been a very busy time, so I hope we can continue this conversation. Just so you know, the recording will be available to everyone who registered, everyone who attended. All the entities here, whether it's ECL, Paddle, NovoJuris, and Serotte Law, have various exclusive offers for everyone who's participated both virtually and here today. to be able to help you along different parts of your journey with both financial and legal advice and offerings. So with that, it's a wrap. Once again, thank you so much for being here, and we will continue to stay engaged and continue the conversation.
Thank you.